Good afternoon, everybody. I'm here just to give you guys a refresher of who we're having on my live today. Let me go ahead and let you guys see some of his previous interviews with us here on the channel. Patrick Menegro. I don't know how to say his name. Menegro. Um, so we're going to go ahead and see his old live with us in here in this channel. So I am going to play our previous interview with him. Just 1 second. All right, let's go. Hello, everybody. Hello, everybody. Hello, hello, hello. Hey, Good Design. Hey, Bree. Hey, Jane Doe. Hey, Henny Hen. How you guys doing? All right, I'm going to go ahead and play. He answered a couple of questions that you guys have. This is going to give you a little bit of knowledge of what to expect on at the hearing and things like that. All right, without further ado, I'm playing my old video of Mr. Attorney Patrick Magro. Okay, he put Meg. Megro. All right.
Sure. So, thank you very much for having me on. My role in life, I guess, is to try to take very complex legal issues and break them down into bite-sized, digestible pieces for people who didn't go to law school, didn't learn this completely different language, and that's really what it is a different language, so that the average person can understand what's going on and be able to make a reasonable and informed and intelligent decision. The reason why the law is needlessly complicated is basically, in my opinion, it's done that way to make sure that the average person doesn't really know what to do, has to consult a lawyer, and still confused. And my motto in life is, or one of my many mottos, I should say, is an informed citizen is a person who is much less likely to get stomped on by an overbearing government. So the more you know, the more you're going to be able to exercise your rights. We're talking about the R. Kelly trial, and what I wanted to do is take a very complex, complicated legal system, which is the federal system, and sort of break it down for the average person to understand. And the appellate process, that is the process for which a person like Mr. Kelly, who's been convicted of an offense, can appeal and try to get some relief in a higher court, because most people are completely aware, or at least somewhat aware of the trial process. What happens in trial court. We see that on television. We see that in the news. That's where people really pay the most attention. Once a case gets past the trial point, it stops being front page news and it ends up on page 6. And it's usually just a small article. Oh, so-and-so won their appeal today. Big deal. Most people don't know what the appellate process is, and that unfortunately includes most lawyers. So let's talk about where the case is at right now. Right now, there's been a verdict. The verdict has been guilty on all of the counts, and there was somewhat of a mixed verdict, which I'll get into a little bit later, but there's been a guilty verdict at least. And the next stage after a guilty verdict is post-verdict motions. In federal court, this is what we call a Rule 29 and a Rule 33 motion. And that's after the federal rules of criminal procedure. And what what the lawyers are going to be doing at this stage in a Rule 29 and a Rule 33 motion is making a motion to basically set aside that verdict and either request or renew their request, I should say, to dismiss some or all of the charges, and to also ask for a new trial. Because you always ask for things in the alternative. If you don't want to give me this, then at least give me that. So when you ask for a dismissal, that's shooting for the moon. But in the alternative, I'll take a new trial. And these are the reasons why I believe I'm entitled to dismissal of some or all of these charges or a new trial. Now, those motions are going to be filed, and probably in the next month or so. I think the due date is somewhere around November 1st. And lawyers are going to be doing their best to try and file a motion for a new trial. The U.S. Attorney's Office is going to do their best to oppose that motion, and the judge will make a decision at some point before the sentencing, which I believe is scheduled for May of 2022. Now let's put aside the possibility of the motion for a new trial at this point, because in reality they are rarely granted. And the reason being is, for a judge to grant a motion like that, the judge has to say, you know what, Mr. Kelly's lawyers, you're right. I did screw up. I screwed up so bad that it violated this man's rights, and I'm going to set aside that jury verdict. I'm going to call foul on myself, and I'm going to set this verdict aside and give this man another shot, because it's all on me. Or in the alternative, it's all on that government lawyer over there. They screwed up just as bad as I did. Now, we know from human experience, the day that the government ever admits that they were wrong is the day that I dropped dead of a heart attack from the shock on the spot. Keeping that in mind, what the lawyer is going to start doing also is simultaneously preparing for the sentencing, because if the motion is denied, as it may very well be, you have to deal with the sentencing. And the sentencing is also a critical, extremely important part of this process, because obviously that's going to determine how much prison time he's sentenced to, and that will set the tone for what happens in the appeal, which is the next step. Now, the federal sentencing process is extremely complex. One of the things that's done is the Department of Probation interviews the defendant, they interview sometimes some of the victims, and they interview some of the other people, and they gather information, and they prepare what's called the pre-sentence report for the court. The pre-sentence report is going to be very, very long, and it's also going to contain a calculation of the federal sentencing guidelines. And like some states, the federal system has what's called sentencing guidelines, and it's sort of like a point system. Now, if you have a prior criminal record, that adds certain points. If a low-level offense will only be worth some points, whereas a higher-level offense will be worth a lot more points. And then there's all these other what they call enhancements, where, let's say, during the course of this offense, somebody used bribery or threats of violence, or used a gun, or someone died, or someone was maimed or seriously injured, or like in the case of Bernie Madoff, the dollar amount of the fraud is over a certain level, or the certain number of victims. These are enhancements that add points. And sometimes there's things that take away points as well. And those are called adjustments. And in any event, just to simplify the process, the Department of Probation will prepare this very long sentencing report. It'll contain a calculation. It'll assign a point value for the judge to consider. And the point value translates into a sentencing range of, this many months versus this many months. And the range, there's the middle range, obviously. After that pre-sentence report is completed, the defense and the prosecution will have their opportunities to object to it, to argue against certain point values or the assignment of points, and to make their own arguments as to what they believe the sentencing range should be, or what the actual sentence should be. And very frequently, defense lawyers will argue that the judge should assign a sentence that is below that point value for a lot of different reasons. So after all of these papers are submitted, the parties will meet. They'll do the sentencing hearing, which will probably be very extensive. In this case, with federal court, they're almost always extensive. It'll be an involved process. The government may choose to present some testimony of witnesses. And here's another little dirty secret that most of the public doesn't know, is in this calculation of sentence, you can actually be punished for conduct for which you were not convicted. Even if the jury found you not guilty, as they did in this case, in their verdict sheet, they found him not guilty of certain acts, the government can and probably will argue that the court should still consider those acts and assign a higher point value, and therefore increase the punishment, even based on stuff that the jury said, we don't find that this was proven to us beyond a reasonable doubt. So if it seems unfair, there's a reason for that, and that's because it is. So he's likely to face punishment for things that he either did not do at all or the jury found that were never proven. Go figure, right? So after the sentencing, then comes the point in time where the case goes up on appeal. And the first step in every appeal is to file what's called a notice of appeal within 14 days of the date of sentence. And that takes the case out of the United States District Court for the Eastern District of New York, which is in Brooklyn, and it sends it all the way across the river to Federal Plaza, not Federal Plaza, I'm sorry, 5 Points, which is the United States Court of Appeals for the Second Circuit. And most of the country, well, all of the country is divided into a number of different districts, federal circuit, they call them circuits. So in the Second Circuit Court of Appeals, that covers every federal court in New York, Vermont, and Connecticut. And basically anyone who's appealing a judgment in any one of those federal courts, you will all go to Manhattan, you go to the Second Circuit Court of Appeals. And that's where that process starts. Any questions so far? No questions. All right.
I'm going to let you guys in now. I'm going to put everybody back in the screens for you to be able to see them when you talk to them. Hold on a second. Sure. All right, here they go. I'm going to unmute them now. Hold on.
Okay.
Yeah, there we go. There they go. So do you have anybody have any questions from what he have said so far?
So basically you saying a legal system is like buying up the way they're making cars now, where they want you to depend on them, where you can't figure it out. Basically it's made for them to be able to put it in these terms because they be able to, that's the litigation part. That's where you go to law school and learn and everything. So that's why they got law school, for you to be able to go learn that. And if you don't, that they charge you to basically it's charging you to understand layman terms through a law system. Does that make sense?
It doesn't just make sense. It's absolutely right. And there's something in the law that everybody becomes aware of at one point in their life, which is ignorance of the law is no excuse. The average person, if you crack open a statute book and you try to read a statute, you will not understand it. And I'm sorry to say, this includes lawyers too. Okay, it's written in complete mumbo jumbo. And I've always said, the cynic in me says it's done that way for a purpose, especially when it comes to federal crimes, because it's so nebulous. It can mean almost anything. And some lawyer had written a book years ago called 3 Felonies a Day. The average person commits 3 federal felonies every day of their life and is completely unaware of it, right? Wow. Did you know that for example, installing a toilet that flushes more than 1.6 gallons in your house or your business, it's a felony.
Wow.
It's like so many things. Like, that's just one example. There's so many of them out there. And this book talked about 3 felonies a day.
It's basically like we jaywalk every day. We're walking criminal, just jaywalking, but they don't use it. But if they wanted to use that to question us, basically the first thing they could use is jaywalking to get us, because that's a crime.
Exactly. And most people don't know that riding a bicycle on the streets of New York sidewalks in New York City, it's a misdemeanor. You can go to jail.
Yeah.
You can go to jail.
Even with the bike trail?
The bike trail, no. But if you go on the sidewalk, like, you're going to park your bike and go into the store or something. Mm-hmm. If you don't walk that bike on the sidewalk, if you're sitting on the bike, even if you're just kind of like scooting along with your feet, not pedaling, go to jail. And they used to actually arrest people for that back in the Giuliani and the Bloomberg era. Used to see that happen in Manhattan all the time. But you're absolutely right. The average laws are written so that the average person can't understand them. And they say, when people say, well, I didn't know. Well, sorry, ignorance of the law is no defense. So yes, this is how far we've come in the past 75 years, 100 years in this country. we've made this law sort of this elite, type of thing where, only the select few that have the money to go to law school or put themselves in debt to go to law school will have the opportunity to understand. And even then, you still don't understand everything because lawyers, this is what they do, is argue over the meaning of the law all the time. And two lawyers can look at one statute and completely disagree on what it means.
Do you see this case filled with a lot of putting in a lot of habeas corpus because a lot of things wasn't let in? So now that when they submitted, there's going to be a lot of habeas corpus that basically because now there's a lot of things that they didn't allow that they possibly have came, so they could put a lot of habeas corpus in, basically just to keep the evidence or just to reserve the information that they give to the judge.
Right, and that's sort of down the line. Now, the step in the appeal is what we call a direct appeal. That's appeal to a higher court, and in this case, the Second Circuit Court of Appeals, just because of where the case took place. Now, what an appeal is not, it's not a new trial. It's not an opportunity to introduce new evidence that was never presented. It's simply it's like looking at a photograph and seeing where the errors are. And the photograph in this particular, in this situation, is going to be the trial record. Any paper that was filed with the court, anything that was said in open court that was taken down by the court reporter, it's all in this box, in this photograph. And that is the snapshot in time that the appellate court, the Second Circuit Court of Appeals, is going to look at. And that's where the lawyers are confined to say, within these four corners of this photograph, this is where the judge made an error. This is where the prosecutor made an error. This is where the jury may have made an error. Whatever the error is that they assigned to that is how an appeal works. Now, when you're talking about habeas corpus, that's a separate proceeding. And that is an opportunity where the lawyers can introduce evidence that was not presented at the trial. And let's say, something comes up that, a new witness surfaces, or I saw one of the audience members had mentioned DNA, if there's DNA testing, or, a video somewhere surfaces, which does happen. That's where the lawyers can file it's called a 2255 petition, but it's the same thing as a habeas corpus. And that's where you file that and you say, hey, listen, my conviction is invalid because the judge or the jury never had the opportunity to review these types of evidence. And these things change the equation in this case. These things change the whole calculus. And if the jury had seen these things, there probably would have been a different result. And that's usually done after a direct appeal is completed. And that's shouldn't be. Because if you win on the direct appeal, you don't need the habeas. So,
yeah. Good morning. Good morning. Thank you for coming. Thank you for appearing right here with us. Two-part. One, I think I understood you to say that this judge could actually sentence him even if it wasn't something or the jury found him guilty on, correct?
Even if they found him not guilty, as they did.
If they found him not guilty, I'm sorry. If they found him not guilty. Now, is that only for this case, or is that for any case? Any sentence?
That's any sentence. Every stick of gum you've ever stolen as a kid. That's for what they call relevant conduct, right? That can be even for stuff you were never even charged with, right? So let's say, and unfortunately this does happen, some jilted ex-girlfriend comes along and says, oh, you know what? You know what this man did to me? He did this, he did that, he did this, he did that. The prosecutor's going to say, ooh, okay, let's put that all into our sentencing memorandum. Would you like to sign an affidavit? Would you like to testify against him? We know this was not part of the charges. This was never presented at the trial. But you know what? This is what we call, what the law calls relevant conduct. And therefore, the judge should take into consideration the fact that this man was maybe, not the best boyfriend in the past, or not the best husband, or not the best father, or, maybe he lied to his pastor, or he stole a stick of gum when he was 7 years old, or whatever the case. You'd be surprised the kind of stuff that they dig up And in a case like this, I would not be surprised in the least if they went back 20 years or more and said, "Oh, he's been a horrible human being all this time," because that actually brings me to one of the other issues, and one of the questions that the audience had brought up, which is, how does a jury come to a verdict like this? How can the government present evidence of what we call uncharged conduct, uncharged misconduct? Well, to be honest with you, in the federal system, there's a rule of evidence called Rule 404B that is the bane of every defense lawyer's existence. And that is the rule that permits uncharged criminal conduct to be introduced against the defendant at his trial. And all this type of stuff comes in. And basically, what the federal government likes to do is engage in character assassination. It's always about everything else you've done. It's not necessarily about the evidence for which exists for these charges, but it's about what a horrible person you are, and therefore the jury should convict you because you're a despicable human being, not because there's evidence here that you've done anything wrong, but just because you're a piece of trash. And unfortunately, the law permits this type of stuff more so in federal court than state court. State courts have, state law usually has additional protections for defendants. It seems like with the feds, anything goes.
I got one more question.
Oh,
go ahead.
Sure.
So
it seems like, go
ahead, Sultry, go ahead.
Oh, it seems like the saying he's innocent until proven guilty, it goes out the window when it comes to sentencing, because if he was found not guilty on that, the judge could still use her discretions and sentence him for that. So why would they say you're innocent until proven guilty? And if he's not guilty of it, he's still sentenced for it.
You're absolutely correct. And, you're experiencing that shock that most of my clients experience when they find out, like, how can this be? I thought this was America, innocent until proven guilty. You're absolutely right. That's because these nuances in the law say, well, after a verdict that innocent until proven guilty, that goes out the window. And that only applies to trial. That doesn't apply to sentencing proceedings. And this is how we create these loopholes within loopholes within loopholes to where, the rule becomes the exception and the exception then becomes the rule.
I got another question.
All right, guys. This is perspective. Did we get to? Because I stepped away. I don't know if we got to the point where some of the things that we were asking about. Let's see. Hold on a second, guys. I don't know what part we were up to, but it's just did we get all the markers? Perspective. Give me the other timestamp because it's almost that time for him, and I want to be ready for when he comes. I want to be ready when he comes in. So we do have questions, and what I'm gonna do the live that we're gonna do with him is going to be members only that can ask questions. If you guys want to ask question, you probably would need to I don't know how you're gonna do it. Did we get it to that part yet? Perspective. Did we get it to that part yet? Get it to that part yet? No, we didn't. Can I get a mile marker that you want me to go? But where are we now? I'll give you the rest. Okay, because we don't have much time. We have I'm gonna give about another 20 minutes of this and then give myself 30 minutes to get prepared for him. I give myself about 30 minutes to get prepared for him. So it's 6:09 right now. 6:09 right now. And what we're going to do, we're going to concentrate on the things that that has been happening in the court system. That's what we're going to be doing. Concentrate on the things that's happening in the court system. Just about 10 more minutes. Hold on a second. I don't have the other phone perspective. Do the main one for me. It's going to be another 10 minutes. I mean, another 20 minutes. It's 30 minutes from now. It's 7 o'clock. Hey, are you in your spot, Pretty Brown Eyes? Are you there? Did you make it? Just want to know if you made it. Oh, you're welcome, Daddy Lolo. You're welcome. Let's see. Say, yo, you don't have to rush. Yes. Okay. Yeah, 10 minutes. That's all I'm going to give. About 10 minutes of this so you guys get to know exactly who I'm having on. He is an appeal attorney. He is very great in teaching. You're on the plane? You still on the plane? Hey, oh my God. Pretty brown eyes. All right, so what I'm going to do, hey, Kimberly, we're going to have Patrick on. He's going to answer some question we have. And he did give some insight. Let me see where we at. Let me just play what we at, and then I'll let you know. Hold on a second. Yeah, y'all can watch the rest, but hold on, let's go.
Hey, can I have your other Alexa in there for our camera?
Oh, absolutely.
Okay, thank you.
I don't even use it.
Okay, because we got some cameras that connect with Alexa, so.
Oh, don't you dare. Don't say her name.
Sorry.
Don't you dare. Unless you want this one, you got Google over here.
No, we gotta be Alexa.
Oh, why you gonna say her
Oh
name?
my God. Okay, bye.
Don't say her name. Sorry, y'all. She keeps saying the thing name over here. All right, let's see where we're at, and then I'm just fast forward on. Hold on, guys. I just wanted to give you guys a snippet of who he is, and those who don't know, so you guys get a chance to hear it. And he's gonna answer the tough questions. He's gonna answer the tough question that we have. See you later. Okay, Dallas was just leaving. All right, hold on.
And the evidence will have those nice foam boards and their presentation. The media will come there snapping pictures. The media and coming in on a case like this, 2 months is America, innocent until proven guilty. You're absolutely right. That's because then these nuances in the law say, well, after a verdict that innocent until proven guilty, that goes out the window. And that only applies to trial. That doesn't apply to sentencing proceedings. And this is how we create these loopholes within loopholes within loopholes to where, the rule becomes the exception and the exception then becomes the rule.
I got another question. Out of all your years, you hear me?
I hear.
Out of all your years trialing, and I'm familiar with some cases, right? And out of all your years, have you seen an attorney come on board on a big federal case 2 months before? And
every minute that's spent in court, a good rule of thumb is 1 in 8. 8 minutes should be spent preparing for that 1 minute in court. And if you have a multi-week trial, that means at a bare minimum, you have that times 8 is the time spent preparing for that. Now, that doesn't include all the investigation that has to go into effect, preparing a defense, reading through all the materials. That's just preparing to come into court and ask your questions and make your arguments. So to me, 2 months is not nearly enough time to prepare. Now, when you talk about managing the media, I've always said there's nothing you can't do when you have the money. When you have the funds, as Mr. Kelly does, obviously, you can hire somebody to deal primarily with the media and the public relations aspect. And, there is a way to do that, and there's a way to do that properly. The trick is, and this came up in one of the audience's questions, is, about boycotting YouTube. And, the problem is you don't have any control over what the media puts out. So that's why you kind of have to have your own public relations campaign, because you need your own channels, your own streams of communication to combat what the official narrative is. Because when you get down to it, the media outlets are generally going to go with what the government says, right? And here's another very unfair thing that most of the public doesn't realize. And I'm pretty sure they did this in this case. What happens is the government will hold a press conference when they announce charges, and they'll outline the evidence, and they'll have those nice foam boards and their presentation. The media will come there snapping pictures, and they've just maligned this person as they've charged him, announced these charges. And one of the first things that happens when they get into court is the judge puts a gag order on the defense lawyers and says, okay, you guys can't talk about the case. But the government has already, smeared my client in the media, and I can't, address that. That happens a whole lot, and that is extraordinarily unfair. And what is also extraordinarily unfair is, certain media channels will, only show one side of the story. That's why you really need your own stuff out there to try to combat the narrative, because as much as we say, we want a fair jury, people are exposed to this stuff on Facebook, social media, regular media all day long. It's very hard to find somebody that didn't hear about this.
But you know what to think, Patrick? Like, okay, like even with my channel, people was like, oh, you don't say things over the internet, blah, blah, blah. And it was like, okay, why are you trying to tie our hands? This is our only means of getting the information out. So, I mean, was that a wrong thing for us to try to get it out through this format type of thing?
Well, your media, you have a First Amendment right to speak your mind. Lawyers, unfortunately, just like sort of like the military, we when we take that law license, when we take that military job, we give up some of those First Amendment rights. So lawyers are limited in what they can say and how they, criticisms they can make. But the general public, people like you, there's no limit to what you can say. You can sit here and criticize till the cows come home. Do I think it's wrong? No, I think it's your First Amendment right. I'm more of a libertarian than anything. So my attitude towards this is, if you have a First Amendment right, exercise it.
Yeah.
Talk to your blue in the face.
But then they were complaining, right. Oh, you bashing the witnesses. You can't do this. You can't do that. If I'm going to expose some stuff that they're doing, why not? Especially those videos. They had videos out there and what they were saying. So why keep us quiet?
As long as you're not defaming them, which is obviously illegal. Defamation is actionable. You can be sued for defamation. Mm-hmm. If you have a good faith basis for reporting on something, if you have, like you said, you have you have videos out there. Looking through the trial transcripts, some of these witnesses admitted that they've lied to lots of people in the past. Mm-hmm. As long as you have a good faith basis and it can be tied to truth, there's, you can bash whoever you want. As long as you're speaking the truth, that's fine.
And that was going to be my question. In the pre-trial, I guess it was established that
introduce evidence, and to be able to bring
evidence, or sustaining objections to questions that the defense lawyers are asking of witnesses, or preventing something from coming out that the defense wants to present to a jury, that helps the defense make an argument that the guy's not guilty for some reason, that implicates those constitutional protections of what we call confrontation and the right to present a defense. That is one of the issues that I anticipate being raised on appeal here, is that the judge's rulings basically crippled the defense. And again, what does it go back to? If the jury had heard this, would the result be different?
Last question.
Most likely.
Last question. This is about the man.
All right, good people. I just want to give you a taste of what's going to happen tonight. I'm going to get myself ready for 7 o'clock Eastern Standard Time. 7 o'clock Eastern Standard Time. I asked you guys to be prepared for some real answers. What I did is I did send him all the documents of what's happening right now with the case. I'm going to give him carte blanche of how he wants to approach it. So get your papers ready, get your pads ready, and I'm going to, ask those hard questions. And it will be restricted to members could only be the ones typing in the chat. My apologies, but I'm not apologizing because the members deserve something today. They deserve something. They have been faithful in supporting this channel. So I'm going to let it be for them to be able to type in the chat tonight for our live. Okay. It's going to be Eastern Standard Time. So it's going to be the members being able to type in the chat and be able to ask question to Patrick. So we're going to restrict it to that. So hopefully you guys will come on and don't be upset because hey, you want to be able to do it? Become a member. Hey, that's it. Member, the one with the green, the green name. And the we have low membership. We got $2.99 membership. It's just members going to be able to type tonight. If you have any question, you'll have to be a member. Hey, trying to make this channel grow now. Okay, we're not playing. But tonight's special guest is only members going to be able to type in the chat. Okay. So I'm gonna be like the big cheese around here. Samuel and the rest of them, they be having membership only. Yeah, shoot. Hey, why not me? I'm gonna think like the big wigs. All right, guys. So to be prepared tonight, for Patrick, he will be on to answer those questions. Yes, I submitted all those documents to him, and let's see where it goes. Okay. And I will be bringing other guests on here too. We're doing great things over here, great things, and bringing awareness, letting people's voices be known. Okay, that is what we're doing here. And also, I want to make this public apologies to my my subscribers in regarding to the childish stuff. You don't have to worry about that anymore, okay? You don't have to worry about that. Thank you for your support. Thank you for your love. I appreciate you. I'll see you guys at 7 p.m. with Patrick. He is going to bring in the information. He is going to give you guys what you don't know. Okay? And you notice how he was answering those questions. He told us about Rule 29 and 33. He told us how the process would go, and as far as the pre-sentencing, and he gave you all that because he's a guru in it. He knows it. He knows the information. He got it. Thank you. Thank you. So just in case anyone hasn't told you, Infamous Sylvie, you are doing a great. Oh, thank you, Lady Coltrane. Thank you. I appreciate you, sweetie pie. Thank you. Thank you. Charles, I got your message. Guys, please keep Charles' family in your prayer. She just got notice that her nephew was killed last night or this morning. Let me see what you said. Hold on a second. I was trying to see what you said. I just looked at the message just now. Hold on a second. Your nephew was killed last night in Chicago. She just woke up this morning and found that out. Yes, you guys, please pray for her. Pray for her family in regards to this. Pray for her, please. Pray for God to strengthen them and during the grieving, and that whoever did this will be found and justice will come about, and that the family will find peace and consolence during this time of bereavement. My heart goes out to you, Charles. Father, bless them. Father God, strengthen them. Thank you, Lord. Thank you, Lord. All right, guys, let me go get off this live and get myself prepared because I need to be prepared for when he gets here. All right. I'll see you guys later. Love you guys. All right. Bye.